When the war powers clock was set to run out then in May of 1999, the Clinton Justice Department's Office of Legal Counsel issued an opinion holding that the supplemental appropriation itself, passed without any authorizing language, satisfied the war powers resolution requirement. So is the department looking to that or intending to rely on that same reasoning that funding alone can substitute for explicit congressional authorization?
Senator, I would have to defer to our.
This is the story of how the Pentagon and the White House figured out they can start a war, let it drag on for months, and just keep hitting reset on the one law that's supposed to stop them. And when they got caught doing it, they didn't deny it. They just said, we have all the authority we need. No debate, no vote, no accountability. Just vibes and Article 2. Stick around, because by the end of this, you're going to understand exactly how they're pulling this off and why nobody in that room was able to stop them.
Secretary Hegseth, I want to ask just specific to Iran authorization. The administration has made the case that the action in Iran falls under the president's Article 2 authorities, and we can have disagreement. Reasonable people can disagree about the boundaries of the presidential war powers, and have for a long period of time. But I look at the War Powers Resolution, and it's not ambiguous. It requires the president to terminate hostilities within 60 days absent congressional authorization. So hostilities began February 28th. May 1st, Congress was informed that hostilities had ended, but yet despite the fact that hostilities had ended, we were still seeing sailors being fired upon still activity. Then in June, an MOU is signed to preserve the ceasefire while negotiations continue. That MOU has now collapsed, and we are seeing the resumed attacks in the Straits of Hormuz. On July 10, the administration sends Congress a new war powers notification, effectively restarting the 60-day clock again. So I'm concerned about this sequence because you have a situation where the claim essentially allows the president to extinguish the war powers clock just at the moment that it becomes legally inconvenient through declaration of temporary ceasefire. Then it's reset, avoiding the congressional authorization that the Constitution requires and the war powers intends. So we had an opportunity in previous appropriations hearing for me to ask if you felt the administration had all the authority that it needed. You indicated at that time that no, additional authority was not needed. Are you still, is the administration still taking that position about needing no authorization from Congress at this time?
Senator, I know there's a long-standing legal debate on this particular topic, but we certainly as a department share the position of the White House that we have all the authorities necessary at this moment. So
let me just kind of do a follow-on. In the Clinton administration, this is 1999, there was an operation that was launched, Operation Allied Force, NATO airstrikes against Yugoslavia. There was not a prior congressional authorization that was sought. President Clinton notified Congress under the War Powers Resolution, and then subsequent to that, sent Congress an emergency supplemental funding request. It was about $6 billion to cover the cost of Kosovo operations. Congress then passed a supplemental package that covered the president's request plus additional military funding. But Congress never passed a standalone authorization for use of military force in Kosovo. When the war powers clock was set to run out then in May of 1999, the Clinton Justice Department's Office of Legal Counsel issued an opinion holding that the supplemental appropriation itself, passed without any authorizing language, satisfied the war powers resolution requirement. So is the department looking to that or intending to rely on that same reasoning that funding alone can substitute for explicit congressional authorization?
The law is not complicated. Congress writes the check for war, not the president. That's not a talking point. That's the Constitution. The War Powers Resolution exists because our founders were terrified of exactly this scenario. A president who decides he doesn't need permission, who just acts and dares Congress to stop him after the fact.
Senator, I would have to defer to our legal department, and we'll get back to you with our views on that. But as of right now, we think standalone Article 2 authorities exist for us to conduct this operation on behalf of the defense of the American people, that the president has those authorities, and seeking this funding is important in pursuit of that and our $1.5 trillion budget. But I wouldn't connect the two without consulting with our legal folks first.
In my remaining time, let me turn to you, Secretary Rollins. I appreciate that you have acknowledged that fishermen are farmers of the sea. I don't know whether you are aware whether any fishermen will be eligible for any of the supplemental funding. They too have faced many of the same challenges that our farmers have with high fuel costs, the impact from tariffs, disasters that we have seen. In the 15 seconds remaining, any help for our fishermen?
Well, I remember having the conversation with you when we were going through the process, and my commitment to you and to Senator Collins and some of our others on across the aisle was that it's time for USDA to recognize our fishermen as part of our farmers of the sea. That's never happened before. We now have an office at USDA focused on fishermen. And so I think as you all move forward with the supplemental, the conversation, and obviously up to you all what that looks like, but very supportive of treating our fishermen similarly to the rest of our farmers. Thank you.
Thank you, Madam Chair.
60 days. That's the number, 60 days to get authorization or shut it down. It's not a suggestion. And what did we just watch? A pattern so blatant, it's almost insulting. Hostilities start, the clock starts ticking. Then, right as that 60-day deadline gets uncomfortable, suddenly there's a ceasefire. Suddenly hostilities have ended. Convenient, right? Except sailors are still getting fired on. Except the fighting never actually stopped. Except a few weeks later, there's a brand new War Powers notification. And guess what? The clock resets right back to zero. You do that once, maybe it's coincidence. You do that on a loop, that's a strategy. That's a White House and a Pentagon that have found a loophole and are riding it as hard as they possibly can because they know Congress won't do anything about it. And here's the part that should make you furious. When a sitting senator laid this entire pattern out step by step with dates, with specifics, the response wasn't "you're wrong." The response wasn't even an actual defense. It was, we share the position of the White House that we have all the authorities necessary. That's it. That's the whole answer. Translation: we already decided we don't need you, so this conversation is just for show. Think about what that means. The Secretary of Defense sat in that room and basically told a member of the United States Senate that congressional oversight is optional, that the people's elected representatives are a formality he has to sit through, not a body he actually answers to. And he said it calmly, like it wasn't even controversial, because at this point, why would it be? Nobody's stopped him yet. Then it got worse. The senator brought up history, a real precedent from decades ago, where a different administration tried a similar trick using funding bills instead of an actual authorization vote to claim they'd satisfied the law. And when asked point blank if that's the playbook being used again right now, the answer was, and I'm not exaggerating, I'd have to check with legal. He's running military operations that involve actual sailors getting shot at, and he can't say whether the legal justification behind it is even real. He'll get back to us. Sure he will. This is what happens when Congress lets the muscle atrophy. When you stop demanding real votes and real authorizations, and you let the president has all the authority he needs become an acceptable answer, you're not looking at a policy disagreement anymore. You're looking at a branch of government quietly giving up its own power because pushing back is inconvenient. And notice something else. This isn't a partisan story, and that's exactly what makes it dangerous. When it's your side pointing fingers, the other side digs in. But this was a Republican senator asking the questions. This was inside the room, inside the party, and the administration still couldn't be bothered to give a straight answer. That should tell you everything about how little accountability actually exists right now, regardless of who's asking the questions. Every time this goes unchallenged, it gets easier to do again. Next war, next strike, next temporary ceasefire that resets the clock right when it's about to matter. This is how you back into permanent, unchecked executive war power, not with one dramatic moment, but with 100 small ones where nobody in the room was willing to make it stop. So ask yourself, if a sitting senator can't get a straight answer on whether we're even legally in this war, who exactly is in charge here? Drop your take in the comments. And if this made you as angry as it made us, hit subscribe, because we are not letting this one go. We'll be back with the next hearing, the next dodge, the next excuse, breaking it all down for you. See you then.